You are listening to the Bail Post. Welcome to the next episode of our podcast. And today we have two returning guests. On episode number 5, we did a podcast about charitable bail funds. And since Texas enacted legislation regarding charitable bail funds, other states have followed suit. I thought today would be a good time to follow up and see what is going on at the current time regarding charitable bail funds. Our guests are Eric Granof, who's the Vice President, Corporate Communications, Chief Marketing Officer, Expert Bail Network of AIA Surety, and Mike Whitlock, the Executive Vice President of American Surety. Welcome, Mike and Eric. Thank you for coming back and agreeing to get us caught up on charitable bail funds.
Thanks for having us.
Thanks, Eric.
I would also mention that just a couple of weeks ago, PBT had their spring fling, and we had a state cook-off competition. Eric was one of the judges, and Mike Whitlock was third place overall, and I was second place overall. So I consider us all winners here today. And congratulations, Mike. If I haven't said it to you, and I keep saying I'm going to send you an email, but congratulations to doing such a good job.
Thank you, and I've done everything I can not to slice my fingers off with that award that they gave you, because that butcher knife is actually pretty sharp.
So, that's right. That's right.
Yeah, very sharp.
Well, you know, Texas now has OCA issues a report annually about we call it the Bail Report, and they issued their 2023 Bail Report, and in it they say in Texas we have 4 counties reporting that charitable bail funds are operating in their county. We have other counties that they're operating under, but they're not operating under the statute. They're claiming an exemption as they're a religious organization. But we have Bexar County, Harris County, Hayes County, Travis County. Texas was the first state that passed a regulation on charitable bail fund. And really that regulation didn't limit the organization from filing anything. It was really a transparency and a reporting requirement. Mike, talk about the Texas legislation from your perspective.
Well, I think one of the things that I found from that legislation was it really just started holding these charitable bail organizations accountable. Who are you? Who are you posting bail for? And I believe it requires them to, to report this information. Well, before they were just kind of working in the shadows, and they were just like a mom or dad to just go up and post one cash bond, but instead they were doing many cash bonds, and effectively they were an ongoing concern and entity in the bail bond business, and they just used other people's money to post bail for individuals seeking to get out pending trial. And that's really kind of been our concern, is that they're doing such volume that they need to be regulated. If they were just doing a one-off, like a church might go over there and post a bond on a parishioner or the son of a parishioner, okay, but they were doing this systematically, large scale, and they just needed to be regulated. So that was refreshing. What Texas did, obviously more could be done, but it was a good first step. Before that, we really only had New York that really just limited charitable bail funds from posting bonds larger than 2,000. That was really the only thing that was on the books on charitable bail funds until Texas passed some legislation.
Well, if we were, we've already done one episode on charitable bail funds, but if we were going to, talk about why are charitable bail funds even a problem? It's, what would you say, Eric? Why has charitable bail funds become this issue that multiple states are talking about?
Well, I mean, I think it's a really good question, because I think you really need to understand the history of these things. And, to sit there and say charitable bail funds are bad, I mean, I think that no one on this call would ever really say that their concept and what they do is something that's bad. It's when they're taking this concept and using it for something it really shouldn't be used for. And I think you can probably see the genesis of that probably has to go back to the George Floyd incident, in which a lot of these charitable bail funds and all the protests that happened around George Floyd, a lot of these charitable bail funds got an immense amount of funding. I mean, funding that was astronomical compared to what their previous donations were. I think the Minnesota Freedom Fund had like $100,000 in their coffers, and then got like $45 million in terms of charitable bail donations to their organization. And now suddenly they had all this money what are they going to do with that? Well, as they started beginning to letting people out, they realized a lot of these protesters were being released without bail. They were being released very quickly. And so to justify these huge bankrolls, they had to find ways to let people out. And their attitude was just bail anybody out without knowing anything about them. And I think you then began to see this lack of accountability and this misuse of these funds to bail out people that probably shouldn't have been bailed out, that were very dangerous, that if they were going to be bailed out using a secured release, it should have been done in the proper way as per what the industry does, the bail industry, in terms of how they, get co-signers and get family members and people around that person on the bond, and that there is real accountability in someone watching that person. And what you saw happen was dangerous people that shouldn't have been bailed out going out and then reoffending and hurting people. And I think that, some of the media around those incidences and the attitude of the bail funds, I mean, the Minnesota Bail Fund specifically, the head of the bail fund did a TV interview. And in that interview, he made the comment like, what we're doing is a big FU to the system and a big FU to the police. And you begin to sit there and say, okay, here's an organization that's supposed to have good intentions, yet he just said the reason they're letting these people out is as a FU to the system. So I think that everyone kind of opened their eyes to really what was happening now with these organizations. And I think that's maybe where we started to get a little bit more critical of their actions. And then you saw some other incidents pop up, and then now a good time for legislation.
The biggest takeaway from our last episode, which was episode 5 of the Bail Post, when we talked about charitable bail funds before, was I think Mike's made the comment that what we were finding, or what the bail industry was finding, is that the charitable bail funds were not bonding out people that we would be bonding out. They were bonding out the people that otherwise would not have anybody to bond out. And that was a big shock to me. I mean, and then since then, it's been confirmed to me that the charitable bail funds have discovered what we've said all along. There's nobody languishing in jail because they can't afford to get out of jail. The people that are in jail are there because they have run off all their support system. They've been arrested enough times that they're career criminals, and that's where they need to be. They need to stay in jail. Mike, talk about that again.
Well, it's just kind of the natural selection of people who are sitting in jail, meaning that, to your point, these are individuals, most of them were serious offenses. They burned their bridges. They've been arrested many times before, perhaps have been convicted of charges, have failed to appear. They have family members that have abandoned them, friends, employers, if there are employers involved, that have simply recognized them for the risk they are. They know them better than the bail agents do. And I know that you're not going to go to court, or I know you're going to commit more crimes, or you're going to do bad things if I let you out. And so they leave them in jail, even though they may have the resources to get you out. They're not going to, because they understand that you're a problem. And so the bail agents, they rely heavily on third-party indemnitors, people stepping up to agree to co-sign for these individuals to stand good on the bond. And if they're not willing to do it, then that's a red flag to the bail agent who says, well, if mom's not willing to get you out, why am I going to risk getting you out? Because I don't know you like your mom knows you. So so that's what I was making the point before, was that, and I even told when I was testifying on legislation here in Indiana, when HB 1300 was passed a couple of years ago, I was telling in my testimony, I said, we don't view these as these organizations as competitors. What we view them is a competitor in the sense that they're another entity that's posting bail for individuals and getting them released from custody. They're not underwriting the risk because they're using other people's money, putting up cash. So they're really not risking their own money. They're risking other people's money. And they have no recourse to return the defendant to custody if they abscond. And so that if you don't have that ability to return them to custody, that's really the hammer that you have for the defendant to say, look, you need to follow these conditions, stay clean, go to court, and you can remain out on bond. But if you violate these conditions, we'll have no choice but to remand you back to custody, return you back to custody. These charitable bail organizations, they do not have those, they do not have that authority to do that. So that was a big concern. And so just randomly posting cash bail for anybody, just because it's the right thing to do, someone shouldn't be sitting in jail. Well, there's certainly a case to be made that some people should be sitting in jail, and there's a reason for that. And there was a matter of fact, I just received a notice from a family that's holding a charity event for their son, Dylan McGinnis, who was a victim of somebody who was killed by someone who was released, whose bail was posted by the Bail Project. And he had been sitting in there for several weeks. The court reduced their bond to, I think it was $7,000. Bail Project goes over there, posts cash bail. Within a few days, he'd killed somebody, this Dylan McGinnis. And his mother, Nikki Sterling, was someone who testified at the hearing. So it was very powerful testimony, and there was just a lot of media attention on the issue here in Indianapolis and in Indiana, because there had been a couple of other instances that were similar to that. And they found out that they were getting county funding. The Bail Project was receiving county funding for administrative costs. So it became an issue of, why are we using taxpayer dollars to provide grant money to an entity who's posting bail for violent offenders who get out and kill somebody? That was basically the line. Sure. For about 6 months in Indiana. It was in the papers everywhere, and it was just it was just, you couldn't stop the bill from passing. It had bipartisan support. The FOP president here was all over it on Twitter. So it really got it passed very easily, which the result was that now these organizations have to be regulated. They have to, they cannot post bond on anybody that's got charged with a violent offense or has ever been convicted for a violent offense in the past. And it really just put some regulation on them. And the last time I heard that they stopped operating in the state because of this regulation.
Well, so I know when the Indiana statute passed and we limited the ability of these charitable bail funds to post bonds, they filed suit. They filed suit. The Bail Project versus the Indiana Commissioner of Insurance, and we did an episode on that. I think it was episode 25, where we talked about the oral argument at the Seventh Circuit, which is in Chicago, Illinois, and how that went. And so they raised 2 points. They said the posting of charitable bail funds or a cash bond for people was free speech. And I thought it was very interesting, because you never realize these old cases that come up. And there was this case called Rumsfeld versus some law school or a group of law schools that were trying to keep, recruiters out of their programs when they had people come in for job opportunities. And they were asking for an injunction to prevent the government from having recruiters. But there was this amendment that they were called, what was it called? It was called the Solomon Amendment, that said you could take away federal funding from colleges if they limited their resources from the federal government. So they were trying to get an injunction from enforcement of the Solomon Amendment so that they wouldn't have their funding cut by preventing recruiters to go to their job fairs. And that's the issue that went up. And the U.S. Supreme Court eventually ruled that that was not a violation of free speech. Those colleges were not taking a position at their job fair on speech. They were just opening it up. And if they opened it up to anybody, then they had to include them. And so in this Bail Project appeal, the issue became, how is posting a bond any more free speech than having a job fair, like under the Rumsfeld case? And I think the ultimate ruling was that it's not. It's the same. Posting a bond in and of itself does not have any speech. You have to have additional stuff. And then on the violation of equal protection, I think the reason why that failed so easily was because both sides agreed it was a rational basis review. And a rational, for the non-lawyers, rational basis is the lowest standard that you apply. And when you apply that, 9 times out of 10, probably 10 times out of 10, the government wins. So when both sides agreed it was a rational basis review, then the government wins. And so, I always look at when a state is looking or a legislature is looking for reforms, you should always look to something that has previously been passed and litigated. I mean, look at in Texas when they limited the use of personal bonds, they had during the pandemic litigated whether the governor could limit the use of personal bonds during the pandemic, and they ruled that he could, and it didn't violate any of the constitutional requirements because a personal bond was not constitutionally protected. And so this would be a good fertile ground now for other legislatures to look at. And, I think Georgia is the most recent state that has included the restrictions on charitable bail funds in a whole laundry list of other things that they passed. What did Georgia do that was different than Indiana and Texas, Eric?
Well, I think that, Georgia's bill, I mean, it had, as you just said, it had a couple components where they made, I think it was 30 new crimes that they were going to require a surety bond, basically a financially guaranteed bond on, so that people weren't just being released for free on them. They determined a group of 30 that were crimes that, were probably a little too dangerous to be released for free. And then another component was that they were limiting the amount of bonds that a charitable bail organization could post every year. And I think it was 3 bonds a year.
3 bonds in 6 months.
And I'm not sure, Mike, correct me if I'm wrong. I'm not sure if there's a financial limit on each of those bonds.
No, it's just you can't post more than 3 bonds within 6 months.
Yeah, I can't post more than 3 bonds. And I just think it's interesting, Ken, because like when you talk about even the Indiana and the bail funds reaction, I mean, you look at it through the lens of a lawyer. If I just look at it from the lens of someone on the street, right? Here's an organization that's doing something that all they're being asked to is kind of be transparent. We're going to regulate you a little bit and be transparent about what you're doing. And their reaction is sue. It's like, what it makes you have to begin to question, what are they hiding or what are they doing? Do they know it's not on the up and up? And then the other thing I would say is, I think it's almost ironic that this organization whose sole purpose is to eliminate bail, and they've been very open about that. They do not want cash bail, they call it, whatever. We call it financially guaranteed bail release. And the fact that they're actually using cash bail to eliminate cash bail, I just think there's irony here, right? Because they talk about when they let somebody out using cash bail, they get a 98% appearance rate. Yet cash bail is bad because it's not a mechanism that's going to mean you're going to show up or not. And it's like, well, you just said that you're getting a 98% letting people out with cash, yet you're saying it doesn't work on the other. It's like their argument is filled with all these conflicts and contradictions, how they want to get rid of us, yet now it's a free speech issue. It's not about getting rid of bail, it's about a free speech issue. At the end of the day, if these groups really wanted to get people out of jail, you know what they should use? They should use a bondsman, because they could pay 10% of what they're already paying, and they'd probably get more of these people out in a more safe and effective manner. But they hate what we do so much, it blinds them to a better way to do it. And they say, what, because we make money. I mean, Mike and I have taken a look at these guys' annual report. The Bail Project, you know how much they pay in salaries a year to their staff?
I'm sure it's incredible.
Their staff?
Yeah.
$9 million in salaries. So they're actually running negative profit, but they pay $9 million in salaries. I think someone should be doing, some regulation looking into that.
That was $9 million on $60 million in cash posted bail, which just the round math would be 10% of that would be 6 million gross premium on 60 million penal liability. So they actually paid 3 million more than that in salaries than they would just writing. I mean, 60 million is just above average. You would call that a large bonding company. One bonding company in California might do $60 million. And they're in multiple states. And so it's just incredible. They've made considerable amount of money being a charitable bail organization.
Well, and I've always said that, this little period of time for charitable bail funds has a finite ending coming because of that very issue. They're running negative every year on salaries, and they're not raising the money that they were raising. And the narrative that they had at the time when they had all these funds sent to them. I don't think it exists today. Not to say they couldn't create a new one, but I don't think that the current climate, they could raise the same amount of money. What do you think?
Well, it almost hasn't existed since they started,
Yeah.
which was low-level offenders in custody who could not afford a $500 bond. Now, I've often said that the one thing that came out of the O'Donnell case and suits like that was really just bringing due cause? What am I thinking here?
Due process.
Was bringing due process to the system, because there for the longest time you did have people sitting in jail on small bonds. A lot of times they were in jail longer than they would have done jail time if they were convicted, if they would have done jail time at all if they were convicted for some of these cases. But it did wake up to the courts to say, we've got people sitting in jail, we better check our manifest to see who's sitting in there and why are they sitting there. Let's get them back before a judge. So once that started happening, that kind of did a lot of cleaning up of the jail rosters in itself. So what was left behind, if you had a $500 bail, is probably because you were there also on a probation or a parole violation,
or a felony charge as well,
or you're serving county time on another charge, but it still shows that you have a $500 bond on a pending case. So I think that's why they may be losing donors now, is because the only people that really are in need of their services are those that have been abandoned by families and friends who are on serious and many times violent offenses that they just cannot obtain, get past the underwriting process with a bail agent, where they post their bond.
Well, it seems like 2 points that these charitable bail funds have been making for a long time. Time has shown that that's not true. I mean, the first point was people really just want to go to court. So they don't need a surety bond. They don't need the bail industry to remind them to go to court, because everybody wants to get their cases resolved. And, I think the failure to appear rates on all these different release mechanisms prove that to be true. And I think over time, like if you agree that we have an 80% failure to appear rate in Harris County right now in misdemeanor court, and that the misdemeanor courts in California have an 80% failure to appear rate, which I've had 3 guests on our podcast confirm that. You can't say that people want to just resolve their cases. They got to be reminded and have an incentive to go to court. And the other thing is, I think what Mike just said is that there aren't people languishing in jail. I've always disputed that people are languishing, that there's people languishing in jail. I don't think I've ever seen that to be true. I think that the bail funds found very quickly that there's not people stuck in jail on a $300 bond. What there were people stuck in is career criminals were in jail because they couldn't find anybody to bond them out, because they had been arrested so many times and they had hurt their family and turned their back on their family so many times that their family finally turned their back on them. And that's a definition of a career criminal, and that's who needs to stay in jail. Don't you agree, Eric?
Yeah, but that's what the same cycle, the same story is what we also see with pretrial services, right? Pretrial services exists to help the people that are the first-time offenders that aren't dangerous, that or maybe have they can't help themselves, they have special circumstances, and they exist in a lot of jurisdictions around the country. But what you find out is eventually, they run out of people to let out, because people are being released already on their own recognizance without pretrial services. And then suddenly, so pretrial services, in order to justify their existence, needs to move up the food chain. And then you start being involved in the releasing of more dangerous people with maybe a little more serious charges. But that's not their purpose. Their purpose was to help the people that couldn't help themselves. And then you get into the whole thing about risk assessments to try to take guys that are risky and make them less risky so that pretrial services can get them out. But so the way the systems work, it's a pretty good system, right? You have judges that have discretion that determine who stays in and who stays out. They set a bond amount. We can come in and we can deal with the people that maybe are a little bit more risky because they have attorneys. We can watch them a little closer. We have all the stuff we've talked about earlier. The circle of influence around them, and we can manage those groups. And then the people that pretrial services are designed for, they should be getting out through pretrial services. And so the system has all the mechanisms in place. It's when other third-party groups try to come in there and change it because they think things are unfair in one direction or this. I mean, the system relies on balance. And when you step away and let it operate, it balances out pretty good. And I think we run into trouble when you get these groups trying to change things, and to, you know, the activists and these progressives to try to do all these different things. It really ends up making in conflict, making problems that maybe weren't there in the first place.
Let's compare, you know, like Texas tried to, when they originally looked at a bill to put restrictions on charitable wealth funds, that ran into a buzzsaw in the House. So ultimately, what passed was really only transparency. You have to qualify, you have to be certified, you have to file an affidavit, designate who you're pointing to have the ability to post cash bonds on your behalf in the county. And then after you post one, you have to do monthly reports to the sheriff. But the original bill would have limited, kind of like New York, the people who could have posted a bond are the people to whom they could post a bond to $2,000 or less. But the House Democrats, or I would say the House, had a problem with that. What was the difference between what the reception in the House in Texas and Indiana's reception of this bill? Was it all because of just of the issues of seeing the consequences of people who received cash bonds?
Indiana was just really one of those years where it just, when you're trying to get a bill passed, that everything is working together. You have local news picking up the story and running it almost every night. We had the FOP president on Twitter every day talking about charitable bail funds. Who are these people? You've got Nikki Sterling, the mother of one of the boys that died at the hands of someone that was released on cash bail. She was out there in media. You had legislators picking up the issue. So it was just, that's all you heard about for 6 months. And then you heard about the Marion County for their crime prevention, their grant money was going to this organization, like I mentioned earlier. So it was just, I mean, it was just everything was coming together at once. It's almost, it's one of those bills that if you were against it, you better explain why. Why are you against preventing people from just being released on cash bail, using other people's money, using taxpayer funded money, and they go out and hurt somebody because they're unsupervised. So that's just what it was. It's just, they had on some very unfortunate situations where people died at the hands of individuals that really, they talk about, if you talk about preventative detention, these certain people should be detained without bail. Well, most states that's crimes as a capital offense or treason in most cases in the state constitution. Well, if you set bail at a certain amount, in this case it was $40,000 for the man that killed Dylan McGinnis, and that he was just being preventatively detained. No one was coming to get him at that $40,000 bail amount. It was only when the bail project spoke to the public defender's office, got the bond reduced to $7,000, and they go in to post a cash bond, and he's out, and then he ends up killing someone. So that was really the system was really working. You set the appropriate bail for the appropriate crime, for the seriousness of, based on the seriousness of the offense, and the person, no one's willing to stand good for them, they stand in jail. That's kind of the natural way of how it typically works. And in this case, someone tried to circumvent it, and then a tragedy happens. So it was really all this coming together, which is why you had bipartisan. It didn't have wasn't unanimous on both sides, but it was near unanimous support for the bill.
In Texas, the largest county that has an involvement of charitable bail funds is Bexar County. And there's an article recently, and their tops is how they're referred to in the news. And there was an article recently talking about they had a large percentage of the people that they were bonded out, or that they bonded out of jail, who were being rearrested in their same case. So, I mean, to me, if they're being rearrested within the same case, that means they have a failure to appear, or they did something else where they weren't supposed to do. And, if a 30%, 40%, just say 30% rearrest in the same lawsuit is a big difference compared to the private industry, isn't it, Eric?
Yeah, no, it's interesting. Is if you we're not asking, or no one's asking, this isn't like the bail industry's crusade against bail funds. I mean, it's not like that at all. I mean, these things are failing because they're failing, right? I mean, all you're asking for is transparency. What's wrong with transparency and trying to find out how it is that you're using this money, where the money's going, who you're getting out, how you're managing that? I mean, that's all this legislation is we're asking about. I mean, and it's not just the bail industry that's concerned about this. I mean, you had legislation jump up in Washington State this year. You had legislation jump up in the state of Kentucky this year. We didn't know anything about that. That was those states saying, you know what, we should take a look at these things and see what's going on. And I mean, if you know, bail works, you know, if you just look at bail, we understand how it works, but just if you look at it from a financial model, right? If you don't get these people back to court, you go out of business. You know, 9 out of 10, if you write $10,000 bonds, you got to get if you get 9 out of 10 back, you still go out of business because you have to pay out a $10,000 bond and you've only collected 9. So the financial model proves what we do works, because if it didn't, we'd be out of business, right? Well, the financial model should work the same with them, right? Well, they're going out of business. Philadelphia had a huge bail fund that closed up shop. Why? Because if someone doesn't show up for court, you have to pay out that money. And they had to pay out the money, and now they've got no money left because they thought they were just going to bail people out, get the money back. Bail people out, get the money back. Well, it doesn't work that way. You have to get them to go to court. And just because you say they go to court and then you go out of business tells you that they weren't going to court. So it's what they do, even though they're doing what they say is the same thing as us, it's not. And it's ineffective and it's dangerous the way that they're doing it.
I've had several conversations with representatives of charitable bail funds, and the first comment that I thought stuck out in my mind is they were like, they actually forfeit bonds, and so they were buying the narrative that they hear in the news. Oh, nobody's forfeiting. Bondsmen never pay anything. Well, we all know that's absolutely not true. And you know, this other thing you keep hearing is, you know, they're a bail fund, so they're going to treat them differently than us, and you know, that may happen for a little while, but you know, you look at this Georgia bill, they were putting in here protections. They were giving concurrent jurisdiction between the prosecuting attorneys and the attorney general to have authority for, you know, if somebody was acting as a charitable bail fund when they weren't supposed to. So they were relying upon the local, but if the local wouldn't do anything, then the state would do something. And they also make it a crime. It was a misdemeanor if you acted as a charitable bail fund in violation of the Georgia statute. We've got issues, I think, in Texas where we need some bootstrap on that, because, you know, if a charitable bail fund decides to give a bunch of money to the local sheriff, well, then the sheriff has a high incentive to lend his ear to them and maybe even give them first choice. But, you know, as the point was made, if, you know, in this day and time with backlogs of cases, a less than 10% failure to appear rate just on the type of release you're using versus a 30% or higher, because we know it's a lot higher if it's a personal bond, then it's, you know, that's going to have a significant impact on the court's backlogs.
Well, on your point, Ken, about you know, certain jurisdictions letting bail funds get away with certain things. Well, that happened here in Indianapolis. Marion County Superior Court judges approved to where the fines and costs would not be deducted from cash deposits put up by charitable bail funds, even though that's in the law that they had to pull those fees out of fines and costs. So dad who puts up his cash for, you know, deposit for his son on a one-time basis, he still suffers fines and costs out of his deposit. But a charitable bail fund who puts up cash deposit on a bond, they weren't required to pay fines and costs out of their cash deposits. That was another thing that was discovered that came up in kind of a smoking gun letter that surfaced during the whole process. Wow. The judges said, no, we didn't give them that authority. And then out comes a letter that was clearly states that they had the authority. Plus in Indiana, the judges clearly let them write post cash bail when it clearly states in our statute, it's unambiguous. It says you have to be related to the defendant within a third degree of affinity and an Indiana citizen to post cash bail in Indiana. Now, the charitable bail fund here, they posted 1,800 bonds over 3 years, in clear violation of the law. Now, Florida, they didn't get the charitable bail funds tried to get the law passed down there where they wouldn't take fines and costs from their cash deposits, and they failed to do that, which is kind of interesting because that's kind of the opposite of what the bail industry. As someone who works in the bail industry, I don't like to see where the courts can take fines and costs out of cash deposits, especially in Indiana, where you can put up 10% cash deposits with the court, because it incentivizes the court to set 10% cash bail because they receive revenue from the bail deposits. It becomes more of a cash deposit to secure payment of fines and costs than it does to guarantee the defendant appears in court. Because either way, if they don't show up, the court gets the money for forfeited bail. And if they do show up and there's a conviction or the case is settled, they get the money from fines and costs. So it's kind of weird. I really debated with the Florida Association of why they were taking that position. But they don't have 10% cash deposit in Florida. So,
well, for our Texas listeners, we don't, Texas does not authorize a 10% bond paid to the courts. We don't allow that in Texas. So there are other types of release that Texas does not recognize. And I would even say that's the Chicago, the Illinois model that they just got rid of primarily. And it's the worst of both worlds because you're paying the money to the court. And so you have nobody looking out for them. There's nobody reminding them to go to court. And the courts then become reliant, or they rely upon the defendant's failures to fund court operations. And I think that's the worst of both worlds when you have a surety bond.
Well, as you know, in Illinois, they got rid of cash bail. So that now they don't even have the cash revenue coming in from cash bail. You just released or detained in Illinois. So a lot of clerks didn't really appreciate the impact it was going to have on their revenues that they've been dealing.
And they didn't replace it. They did not replace the revenue that they took away by their actions.
So 50 or 60 years, they've been relying on this cash, this money coming in from the fines and costs pulled from cash bail, as the state of Oregon did, and still does, as Indiana does. So it's just a revenue generating source that really.
Because on June the 5th here in Texas, we're going to have a hearing on the Senate side at the Criminal Jurisprudence Committee, I believe. And one of the things that they're going to look at on their interim charge is charitable bail funds. So, and what would you, first of all, what would you say to the Texas legislature about what you're seeing across the country on charitable bail funds?
Charitable bail should be for nonviolent offenses. That if it's a violent offense, that they should be prohibited from posting cash bail through a charitable bail organization, which is the case here in Indiana, which you cannot do that. And clearly Georgia basically made it to where you could do 3 bonds in 6 months. And
I think it's over a year. It says posted per year.
Well, I read it as 3 bonds in 6 months, or 180 days is how I read it. But anyway, be that as it may, that they have to continue to be transparent of who they're posting cash bail, and maybe even open up who their donors are, who's making the contributions to these organizations. But definitely, if you can't limit the size of the bond that they can write, like New York does up to 2,000, limit the type of charge that they can post cash bail on, meaning no violent offenses.
Eric, what would you tell the Texas legislature or the committee on June the 5th about charitable bail funds?
I mean, I think what Mike just said was good. I mean, I like the idea of, maybe, putting some limits on the types of bonds, that it has to be nonviolent, putting an amount of the bond that it can't be higher than. I mean, I think you can't give these groups free rein because that's not the purpose of what they're for. Charitable bail funds are to help the people that can't help themselves, just like pretrial services. And I think if you start opening it up that they can bail anybody out that they want, I think then you're creating a recipe for disaster. And I think that we need to kind of keep them in their lane and maintain the balance in the system. And I think, I think by putting those kinds of restrictions on what they can do, I think that helps do that.
I think if the narrative, what the public was voting on is, should we have charitable bail funds to help protect the poor? We know what that result is. But if we were also to ask the question, do you want charitable bail funds to be able to bond out career criminals or to bond out violent offenders? I think we can guess what the result would be there too. And so I think what the reality, the rhetoric versus the reality is they're arguing that people are getting stuck in jail. The reality is they're bonding out career criminals. Do you agree, Mike?
Oh, well, absolutely. As we mentioned earlier, that's really the pool of client that they have now, is because all the low-level offenders are making bail or being released on their own recognizance. So the only way they have to justify their existence and justify their request for additional funding is to post bail. And the only people left in the jail that post bail that haven't been bailed out through a bail agent or family posting cash bail is violent repeat offenders in most cases, again, which they do not have the ability to supervise and to return them to custody in the event of a violation of their conditions of release. If there even are any, probably the main one would be failing to appear for court. They don't have the authority to bring them back to court, and that's the basic nature of bail, is to guarantee the appearance in court. Bail is a surety product that we write, which is a financial guarantee. So you either produce the defendant or you pay the bond. I mean, it's really pretty simple how this all works. And to ensure our risk, we bring in third parties to indemnify us against loss. So in Eric's analogy of, with 10,000 out of 10 forfeits, it could put you out of business. Well, it may, if you didn't properly secure your bond and get third-party indemnitors who are going to reimburse you for that loss, which is how it's supposed to. In theory, you should never take a long-term loss if you've secured your bond properly. You're either going to put the person back in jail timely, or you're going to recover your loss from your third-party indemnitor.
It seems like we're coming out of this period where the pendulum has taken a really hard swing to the left, and it's starting to either come back to the middle or even starting to push in the opposite direction. And, Texas had sweeping bail reform 2 sessions ago, and we're starting to see sweeping bail reform in other areas as well. We've got South Carolina, we've got Georgia, we've already talked about. But if you were, Eric, if you were to talk about what this sweeping reforms is looking like on the other side, as we're coming back to the middle, what would you say are some of the common elements of these reforms?
Well, I mean, I think what's happening, it's kind of like you would say it's the natural knee-jerk reaction to crime, right? What we've done over the past decade is we've created these soft on crime policies that were designed to be more fair, right? And what they did was in my opinion, I think they've unleashed a crime wave like this country's probably never seen before. And so now the knee-jerk reaction, well, this isn't working, we need to lock more people up. So as you talked about that pendulum swinging, the fear is that we swing it all the way back in the other direction, where now suddenly you're preventatively detaining people. And the challenge with that is that a lot of state constitutions say that you can't preventatively detain people. Well, what we're seeing in several legislatures right now is states that are looking at preventative detention measures where they're going to change their constitution so they can allow for preventative detention. You have states like Connecticut, Ohio's looked at it, Delaware, even I know Texas and Indiana, they've all kind of looked at this idea of creating a way with that they can preventatively detain people. Now, as citizens, you might think that what's good, we want to be able to do that, but you always have to kind of keep in the back of your mind is that there is the concept of innocent until, the way our system works is that you are put in jail based on probable cause. And then if you're determined to be way too dangerous, or the charge is a capital, as Mike said earlier, capital charge or treason, whatever, then you can be detained. But until then, the bond is set and you're able to be released, released to a surety of your choice, okay? Well, if we begin to eliminate that and detain these people, now you're going to have the other side of the equation, which basically becomes the federal system. And in the federal system, when it was first implemented, this idea of preventative detention, you had what, a 20%, 24% detention rate? That detention rate's 70-something% now. If that's what we want to do, is to give the ability of these states to detain anyone they want you are going to move that pendulum so far to the right that you are going to have jails more full than they've ever been full before, with people that have no chance at release, that may be innocent. And just because of the nature of a charge, they're going to be held. So when the pendulum moves too far in the other direction, as I talked about earlier, it opens up a can of worms. When it moves too far in the one direction of being too soft on crime, it opens up a can of worms. So the idea is that balance. Where is it in the middle that we need to maintain? Because the system, like I said, has the mechanisms to handle both extremes. And you just got to let it operate in the way that it's been designed, which has been effective for a long, long time.
On the preventative detention, of course, they have passed it, the version, the preventative detention in Indiana, at least the first round. It's going to come up again in 2026. And in the interim, they're doing they passed a 2-year study committee on bail. But my point, and really to Eric's point, is in Indiana Constitution, it's been the preventative detention has been capital offense and treason since 1816. So for 200 years later, they're now considering expanding preventative detention in Indiana. Why? What has happened in 200 years, over 200 years, that today in 2024 is now's the time we need to expand preventative detention? What's happened is 7 or 8 years of bail reform. Okay. And the fact that prosecutors are not prosecuting crimes and charges and offenses. There's arrests are down because prosecutors are not prosecuting crimes. Cases are taking as long as 2 to 3 years to go to trial. In South Carolina, when they did their whole bail reform last year, one of the things that's brought up in South Carolina is the district clerk said the cases are taking 550 days to go to trial. Well, that just gives someone who's out on bail plenty of time to continue to get into more trouble and continue to increase the cases that they have, realizing that their case is going to fall apart against them because witnesses are going to move away or disappear or whatever. Evidence is going to fall away and they're eventually going to dead docket the case or whatever, make it go away. So that's why you can start building these career criminals, because they're never getting prosecuted and convicted if if the case should be convicted. So the idea that they're having to now touch the third rail of amending the state constitution after 200 years because their policies have gotten so bad, and so we're so ill-informed, or the unintended consequences of bad legislation have resulted in now trying to say, well, let's keep all the bad people in jail. Okay, well, some people you perceive are bad are not really bad. It's just someone else saying that they're bad, but they have a chance to defend themselves in court. That's why you have a trial, and they should be released on bail. So now you're picking winners and losers as a judge. Now
but that's also a charge-based release mechanism system. I mean, we're going to hold all these people that are charged with these crimes.
Sure.
And in that, the lesson that we just learned from the pendulum swing to the left, if we're going to have just charge-based mandatory release with no ability to hold accountability, I mean, that's the same problem, but the opposite side of the piece of bread. What we need to have, I mean, to me, it seems like the big problem for the last few years is judges refusing to implement accountability. And when we fill up the jails, look at the jails as a result of COVID. We've gotten rid of all accountability in some areas on misdemeanors. And now the jails are still full of really bad people. And so we have no ability, absolutely no ability to hold people accountable on failing to go to court on misdemeanors because the jails are already full if we're wanting to be fiscally conscious of what we're doing. And so my concern is if we go down the road of preventive detention, that's the same trap. You fill up your jail with the really dangerous people and you have no way to hold anyone else accountable. And look at California. I would say all of California's problems right now are because they refused to build additional jail capacity. They were capped at their jail capacity for the state at 137.4% from this federal litigation that went all the way to the U.S. Supreme Court, and they affirmed on 5-4. And, the dissent, Alito said, you're releasing the equivalent of 3 divisions of convicted, really dangerous criminals. We can't harbor that. And this is all about medical. They're not getting the right medical treatment. So why are we not limited to releasing those people? We're just doing across the board releases. And he said, you're going to get the same result Philadelphia got. Every place that's tried this. But instead, what do we hear in California? Oh, releasing more criminals will make you safe. When all the past experiences is when you release more criminals, you're going to have more crime. And what we see in California is we've had more crime, but they won't acknowledge it. And I think, I had a guest 2 podcasts ago from New York, and he made the comment, legislatures were saying behind closed doors that they were willing to put up with more crime to get their political agenda passed. I don't know how, if our friends on the left will not admit their policies are not working, then how can you conclude anything else than that was their intent from the beginning, was to implement a policy for failure or that would increase crime. And now they can't admit it, because if they admit it, they know the voters are going to turn on.
But Ken, I think it's even, it's interesting. There's an article today that I went ahead and put out on social media, and the article was some group, and I forget what state it was in, but it's a picture of some think tank, and they're saying we have to find ways to reduce incarceration in this country. And I say to myself, why is the question we have to reduce incarceration instead of the question being we have to stop people from committing crime? That's never the question they want to answer. It's how do we make things that people are doing not crimes? That's their solution. Or how do we let people out of jail so we can say that there's less people in jail? But it doesn't get back to the fact that there's people out there that feel they have the ability and the free range to do whatever they want and commit more crimes than we've ever seen. And I think that we need to focus on that problem. And somehow this whole bail reform has created this problem-solving frenzy in an area where maybe nothing was really broken. Maybe you just have too many people coming into the system, and the system's too slow to process them all. So our scapegoat is going to be find mechanisms to release them as fast and as simple as possible so that we don't have to actually fix the problem, which is the system.
Well, one of the things that I always kind of laughed to myself about when I heard this argument was, just would go back 10 years is, crime is down. Why do we have all these people in jail? There's too many people in custody. And it's like, well, crime is down because all these people are in jail. That's why crime is down. If you let them all out, like they did in 109 and with Prop 47, where they get rid of, basically property crime and drug possession, serious drug possession, which is why they have the problem out there that they have right now, and they're trying to remedy. And I think it was 109 that brought state felons down to the county level and start housing them at the counties, probably to get out from, keep their jail population.
That's exactly
down.
what it was for.
Yeah. So now, and to your point, they didn't have the resources to provide people that are typically serving state time, education and all these things. And they don't have that at the county level, which means they had fewer beds for the everyday people that are just getting arrested on this, that, or the other thing. So they didn't have room. So they're trying to release them as quickly as possible. So it's just kind of become a mess. I know there's something that came out with, is it U.S. Representative Fitzgerald is looking to do something at the federal level to address weak bail policies there as well. So it's a problem that you're starting to see the wind changes. South Carolina, you mentioned earlier, that was more about regulating bail agents than it was doing.
I'm glad you brought that up, because one of the things I want to highlight about the South Carolina changes, and I know it was sweeping bail reform, so it involved so much more than what I'm going to mention. But, in Texas, we teach bondsmen all the time that when they request, file an affidavit to request a warrant, that they can't file that for lack of payment. But if they're not paying, they're not doing other things as well. And if they're not, there's a couple of cases that have a list of things that you can surrender a bond for. But I thought it was interesting that in the South Carolina reforms, if the defendant fails to pay his GPS or fails to pay on a payment plan with the bondsman, the statute requires the bondsman to not only report that, but to surrender the bond. Now, that would be a humongous change in Texas. And I would say that's one of those where maybe the pendulum is swinging too hard to the other direction, because I think the lessons from all these bail reform is you want people to come to court, you need more and more on a surety bond. If you don't care, I've actually told judges this, if you don't care whether your people come to court, then you don't need us, because that's what we do. We get people to come to court.
South Carolina was an interesting state because they were quiet. Everybody else is doing reform for 7 years. And then South Carolina was doing nothing. And then all of a sudden, boom, here comes this bill where they wanted to make all these changes and add regulation on bail agents in South Carolina. And it had a lot of support from leadership. And so it was going to pass. It was about getting in there and making arguments a while. Maybe some changes could be made. But yeah, one of the things that really I found interesting was that they have to take, at least the interpretation is and there's some argument about the interpretation, but right now the going interpretation is that you have to collect 10% up front. So basically, if you can go as high as 15% premium in South Carolina. So if it's $1,000 bond, 150 is the most you can charge, but you have to charge and collect up front $100 minimum on $1,000 bond. And you could put them on the balance of it, additional $50 on the over 10% amount. If they enter into a payment plan and they miss 2 consecutive payments, you must return them to custody. So it's kind of a debtor's prison type of argument. Yeah. Very few states, I think maybe Georgia, you might be able to surrender for failure to pay premium, but obviously I'm opposed to that. I think it's a contract issue between you and your client, how they're going to pay. But that's just how severe that they made it in South Carolina. So very interesting what they chose to focus on. They use a lot of electronic monitoring, ankle monitors in South Carolina. A lot of the bail agents provide those monitors. Now they've tied, if they violate the monitor, the conditions of the monitor, that they can now forfeit the bail for that. And so that's something that's fairly new in South Carolina. There's been versions of that, as courts have tried to hold bondsmen, but now they've codified that in the law out there. And you have to now have a property and casualty license, where you just had to have a bail license before. So yeah, there's some different things that is going on in South Carolina. Probably the most comprehensive bail regulation in terms of regulating bail agents specifically that's happened in some time.
Was there any indication that the South Carolina reforms was a backdoor attempt to limit bail that bondsmen were writing? Because it seems like to me that when Texas doesn't regulate the amount of bail that you write, or what you charge on a bond, but the Harris County Bail Bond Board enacted a local rule, which is currently in litigation. And we may have an issue at the legislature next session on it, but it seemed like to me that what happened in Harris County was an attempt to blame the bondsman for increased crime. In fact, the commissioner's court was the one that started the request for that local rule. And I would say as bail or people being released on surety bonds went down, crime has gone up. But the bondsmen were blamed for the increase in crime, and they were saying it was because they're not charging enough money, where 2 years ago it was we're charging too much, we're not working with people. And seems like we get caught up in politics in that situation.
To your point, that was the argument for many years. Bail is not affordable, but bail agents charge too much money, and then all of a sudden it just flipped on its head. Now bail is too affordable, so we need to make sure that they pay a minimum amount up front before they can post bail. So which is it? Is it affordable or is it not affordable? The bottom line is when they get out, they're out on secured release. And you should be more concerned about the bail amount and how that's going to be paid, not how the bondsman gets paid. It's like, well, I appreciate you looking out for me, courts or judges, that's making sure that I get paid. I appreciate that. But the reality is, we're just trying to make it affordable for someone to get out of jail while still protecting ourselves.
Well, when Harris County, that the sheriff immediately asked for, I think, at least another $28 million, and because of additional people that would be in jail. And
but we didn't see anything, Ken, like leading up to South Carolina. Like Mike said, it was quiet. So it wasn't like we had all these issues about payment plans and undercutting, and it was like they had a conversation or went and looked at every state around the country and what they did with bail reform, and they threw it all into one bucket and tried to pass it. And it was really kind of unorganized, and that there was actually some pretty detrimental stuff in that bill that really would have hurt the industry that we did get removed. And there were negotiations that happened, And as Mike said, right now, the big issue is the interpretation of what was passed, whereas the negotiations that happened had a purpose and everyone was kind of in agreement, but then the DOI gets it and interprets the payment plans in a completely different way than what was the intended debate and negotiation that had happened.
Let's kind of look in the crystal ball for a moment. You know, if we were going to advise, you know, legislature like the Texas legislature or South Carolina or Georgia, or, you know, these other states like California and New York, if you wanted to improve the criminal justice system, because I argue whatever improves the criminal justice system is going to be good for the bail industry because they're so intertwined. But if you wanted to enact some policies, to me, limiting so that career criminals could not be released on charitable bail funds would be positive for the criminal justice system. But, you know, what are some of the things that you're seeing other than, you know, what we've already talked about, the limiting the offenses that can have personal bonds released, used on? What other things have you seen or do you think would help improve the criminal justice system and bail in bail reform?
I honestly think that you need to leave the mechanisms by which you release people from jail. I think you need to leave those alone.
Mm-hmm.
I think right now we have a mental health crisis in this country like we've never seen before, and nothing is being done. You have all these promises by all these government programs and pretrial services that they get these. We need to put money not into releasing people, but we need to put money into getting them the help they need, whether it's drug and alcohol abuse, whether it's anger management, domestic violence issues, whether it's homelessness, whether it's mental health. We need to get these people the help that is just not available to them right now. There's too many promises being made, but then not enough follow-up on it. How they get out of jail, that works. What we've been doing has worked for hundreds of years. It's just they need to focus on, once they're out, how do you ensure that they're going to go to treatment? How are you going to pay for that treatment? How are you going to get the people the help they need? To me, that is the number one problem in our criminal justice system right now, in terms of the inflow and the constant, repeat offenders. There's mental health issues that are driving all this, and I think that we really need to focus on that.
We're in a period where mental health is King's X. Okay, you've got a mental health issue, so we're not going to prosecute you for that crime in some areas. And so it's just release you, and then you get released and you commit another offense because, like you said, the larger issue is not being addressed. We've got to get away from the King's X mentality where we can't do anything to you and we don't have the ability to help you. So we're at a detente when more victims arise. Mike, what would you add to the discussion?
I would add common sense. I would add common sense and go with what's worked for 100 or thousands of years, which is if you commit a crime, you're arrested, charged, you go to trial in a reasonable amount of time, and if you're convicted and the charge carries a sentence, that you get a sentence and you get off the street. And one of the things that we have, a very smart criminal population, at least the repeat offenders, they know what they can get away with. Mm-hmm. So the minute you start showing them that they can't get away with it, then they smarten up mm-hmm. and they tighten up and they start committing fewer crimes. So if you just like shoplifters in California, Sheriff Cooper out in Sacramento, he's now started staking out big box stores for shoplifters to try to curtail crime. Once you start arresting people for actually committing these crimes, they'll start committing fewer crimes, and more people will start to say, oh, wait a minute, I can't get away with that anymore. So start holding them accountable. Mm-hmm. I'd get rid of the 10% deposit option. There should be truth in bail. If it's a crime and the bail is $5,000, the bail should be $5,000, not a 10% option, because now it's $500. So which is it, $500 or $5,000? Pick one. And then whatever it is, you should have to put it full cash. I
like that a lot, because the courts end up relying upon that 10% for court operations, and that makes it the worst of any option.
Yeah, it's a scheme. It's nothing more than a scheme to make money for the court. The court's now in the bail bond business, but they don't have that pesky part.
But they're also in a bail bond business relying upon defendants' failures for them to make money.
Well, they are, but remember, they get fines and costs out of at least in Indiana, they get fines and costs out of that cash. So all of them can show up to court, but they still make the money from fines and costs. So get the courts out of the bail bond business. Okay. So I would do that. And then I would say, require a hearing for a defendant to have been in custody 72 hours after arrest that still hasn't posted bail. Okay, and that's kind of the due process argument. So get them before the judge for a bail review. Now the judge may say, look, based on the seriousness of the crime, your bond is what your bail amount is apt for the crime that you have, or you know what, we could review that and maybe release you on your own recognizance or reduce the bail. That would address a lot of things. So if you're still in jail after that 72-hour review, then more than likely, and no one's willing to get you out, then that kind of deals with the preventative detention issue, because now your crime's too severe. You've lost your third-party contacts to help you get out of jail, and the bail agent's not going to get you out of jail. So now you're going to be detained really because of just your own criminal history is kind of dictated. Your past is caught up with you, so to speak, and now you're sitting in jail. And so, which is probably where you need to be. So, and then certainly, if I didn't say this before, reduce the amount of time it takes cases to get to trial.
Mm-hmm.
You know, we can go back. There used to, in California, your cases used to be disposed in 90 to 120 days. Okay, on most of the cases. I'm researching cases now that we're going into third or fourth year on some of these cases. Indiana as well. It's just absolutely insane. That's beyond our control in the bail industry. Okay.
One of the two shocks that I've learned in the last 2 weeks is in California, DAs that were supported by Soros, not California, but wherever Soros DAs were supported, one of the common themes of them is they're not filing charge enhancements for weight of drugs. Mm-hmm. And so the example that was given to me, I think on our last podcast, was a drug dealer was arrested, had 40 pounds of cocaine with him. And but Gascon would not file the enhancements for the drug weight. And so instead of getting 20 years, he got a few weeks and was released. I mean, I can see a criminal element thinking that's the cost of doing business. And that's a problem. I mean, we've got to, the public will demand public safety. And if we're going to give up on public safety, it's not going to go away. And then kind of the last thing I would kind of highlight is, we've had all these reforms going on for a while in the name of we need to be more fair. We need to have more equity. And if you look at where we are, look at California's jails now, look at New York's jails. Maybe they're down a little bit, but look at the racial makeup. The racial makeup in the jails are the same as they were before these reforms. And so if we had truth in these arguments, they would be saying, well, either they didn't work or we don't have systemic racism like we thought we did. And I would argue that we've got proof that we don't have systemic racism because they've done all these changes and the racial makeup of their jails is still the same. Guys, thank you so much for talking today and kind of bringing us up to date on bail funds and then talking about reforms that we're seeing across the country and seeing how we're having a pushback on these bail reforms that have kind of removed accountability and how we're kind of getting back to the way we should be operating. We should just get people out of jail and get them to court, get the case processed, and then go on about our business. But thank you so much for talking today. And I hope to see you again soon. And I hope your steak improves the next time we have this cake competition, because I'm going to kick your butt if you're next time too.
Third was just the first time around. I was very shocked to take third. I expect to take, I was very shocked to take third. I thought I had first in the bag, especially with my sides.
I was prepared to just crow about any position I got, even if it was last. I would have been crowing about it because I didn't care. Well,
I had that odd sensation when you announced like my name called for third. I said, "Oh, that means I didn't win." I still picked third place. So after it was all done, I realized, okay, well, third's not so bad. But it's that immediate reaction, like, "Oh, I didn't win."
It was a lot more fun than I was thinking it would be, but it was a great fun blast. I hope we do it again.
It did take me 24 hours to recover from eating 13 different steaks. So
I can imagine. Yeah, that's a lot of meat.
Yeah. Okay, guys. Thanks a lot. See you next time.
Take care.
Thank you for listening, and come back for the next episode of The Bell Post.